Sorry, I'm going to have to read because there's a little bit of information here, but it won't be too long. On January 21st, 1963, Congress passed Public Law 87-849. This amended Chapter 11 of Title 18 United States Code. Notably, it revised Section 201, which is the bribery of public officials and witnesses. Most important for the purposes here is that the definition of public officials at that time included members of Congress. All right, so remember that, it's important. Over several decades, the criminal conflict of interest law shifted in many small ways. However, they didn't change who was punishable under the codes. However, a significant shift in the definition of officer and employee concerning certain conflict of interest statutes occurred in 1989. With Public Law 101-194, that amended Section 202 of Title 18. Specifically, in subsection C, the following language was added. Except as otherwise provided, in such sections, the terms officer and employee in sections 203, 205, 207 through 209, and 218 of this title shall not include the president, the vice president, and members of Congress or a federal judge. So what does this really mean? This means that they explicitly removed Congress, the president and vice president, and the judiciary from being charged with Section 203, compensation to members of Congress, officers, and other matters affecting the government. Section 208, acts affecting personal financial interest. And Section 209, salary of a government officials payable from non-governmental sources. And that basically sums up all of the information that's in there. It is much more detailed. However, that's a summary of why certain criminal conflicts of interest laws just don't apply to the elected class of our nation.